Are you a foreign investor looking to purchase property in Houston or just in Texas in general, and you're wondering how this will impact you from a tax perspective? Well, I am not a tax professional, but if you watch this video, it could provide some insight and help. Before we get started, I'm Natasha Carroll, your local Houston, Texas realtor and relocation expert. Today, we're going to discuss FIRPTA, Foreign Investment and Real Estate Property Tax Act. It is a U.S. federal law that governs the taxation of foreign individuals or entities in a real estate transaction. Enacted in 1980, FIRPTA is designed to ensure that the U.S. government can collect their taxes on gains made by foreign parties from the sale or transfer of the U.S. real property interest. You may say, how does FIRPTA work? There's a withholding requirement. FIRPTA requires the buyer or transferee of the U.S. real property interest to withhold a portion of the sales proceeds at the time of transaction. The withholding amount is generally 15% of the total sales price, but it can vary on your circumstances. Identification of a foreign seller is also a requirement. The buyer or buyer's agent is responsible for determining whether the seller is a foreign person subject to FIRPTA law. This determination can be made through the completion of an IRS Form W-7, which requires the seller's taxpayer identification number and other relevant information. There is, of course, exceptions and reduced withholdings to FIRPTA. Certain exemptions and reduced withholding rates may apply to specific cases. For example, if the sales price is below a certain threshold, currently $300,000, or if the buyer intends to use the property as their personal residence and the sales price is below a higher threshold, currently $1 million, the withholding rate may be lower or it could be waived. However, it is important to consult with your tax professional or an attorney to determine the applicable withholding requirement based on your specific situation. There's escrow and reporting requirements. The withheld amount is typically held in an escrow by the buyer's closing agent or settlement officer. The buyer is responsible for remitting the withheld funds to the IRS within a specified time frame after the transaction is completed. Additionally, both the buyer and the seller are required to file specific IRS forms such as the 8288 to report the transaction and provide necessary details to the IRS. There are tax liability and potential refunds. The withheld amount represents an estimated tax payment for the foreign seller. The actual tax liability is determined when the seller files their U.S. federal tax return for the year in which the sale occurred. If the actual tax liability is less than the amount withheld, the seller may be eligible, of course, for a refund from the IRS. That's exciting to everyone, of course. There's responsibilities of the buyer and the seller. The buyer's primary responsibility is to ensure compliance with FIRPTA, withholding requirements, and remit the withheld funds to the IRS. The seller is responsible for filing the necessary tax returns, reporting the transaction, and paying any additional taxes owed to the IRS. FIRPTA, of course, is an important federal tax law that applies to foreign individuals or entities involved in a real estate transaction in the U.S. By withholding a portion of the sales proceeds at the time of the transaction, FIRPTA aims to ensure that the U.S. government can collect any gains made by foreign parties from the sale or transfer of U.S. real property interests. Buyers and sellers should be aware of their obligations under FIRPTA and, of course, consult with a tax professional or an attorney to ensure compliance and understand the specific requirements and potential exemptions that may apply in particular situations. If you found this information was helpful, don't forget to hit that subscribe or like button. See you on the next video.